Good evening, everyone. We're going to begin shortly. The judges are on their way. We just want to thank you all for coming. We're very excited to have the final round. We believe the teams that are here are going to do a fantastic job. We're very excited. We have 3 different judges from 3 different federal courts of appeal with us. Judge Kozinski from the 9th Circuit, Judge Stucky from the Federal Court of Armed Forces, and Judge Benton from the 8th Circuit. As a practical matter, we're just going to have, after the round is over, the judges will then indicate that they're going to go deliberate. They will leave the room. Please hold your applause until after the judges have left for the competitors. We'll applaud for the judges after they're done, but just as a practical matter, it'll make it easier for us. The judges will be here shortly, and we'll just have you guys all rise for that, and then the round will get underway. Thanks.
I'm going to stand right here and then open the door for you when it's time.
All rise.
Oyez, oyez, oyez. The Honorable Supreme Court of the United States is now in session. The Honorable Justices Kozinski, Benton, and Stucky serving. All parties having business before this court come now and be heard. God save this honorable court.
Good afternoon. Please be seated. We have on the calendar Roberts versus Town of Somerville. Counsel ready?
Yes, Your Honor.
You may proceed. Petitioner may proceed.
Mr. Chief Justice, and your honors, may it please the court. Initially, I'd like to request 2 minutes for rebuttal.
Could you identify yourself?
Pardon me, your honor?
Plus who you are.
My name is Cherrelle Hooper, and my co-counsel is Joanna Robinson. We are here today on behalf of
Keep
Petitioner
that mic
Roberts.
and point it to your lips. Lips.
We are here today on behalf of Petitioner Roberts. Initially, I'd like to request 2 minutes for
You're Ms.
rebuttal.
Cooper, right?
Yes, sir.
Your co-counsel is Ms. Robinson.
Yes, Justice Kozinski.
Go ahead.
Would the court like a brief recitation of the facts?
You're the lawyer.
The issue before the court today is whether the protest policy in enactment or enforcement was content-based or content-neutral. We submit to the court that the protest policy was content-based in enactment and that there was viewpoint discriminatory enforcement.
Counsel.
So what?
We ask this court to affirm the district court's grant of summary judgment to Petitioner Roberts. I will focus on the protest.
What are you seeking? What is your client seeking in this case?
We're seeking summary judgment, Your Honor.
Oh, you can't
Yes.
do anything with summary judgment. You can't buy anything with it?
Your Honor, I will be.
You can't. What are you going to get when if you win this lawsuit? What is your client seeking?
He's seeking that this declaratory relief that this policy is unconstitutional.
Is he declaratory relief?
Your Honor, ultimately, we're asking for summary judgment.
You're not asking for an injunction against its enforcement or anything like that?
No, we're asking you to affirm the district court's grant of summary judgment, Your Honor.
Well,
Yes, but to what end? I don't have a complaint in this case. I don't know what the record, what the complaint seeks. I'm trying to figure out what kind of relief you seek, because depending on what kind of relief you're after, it depends on what, it matters a great deal in determining what kind of claims you can bring against these various defendants. So are you seeking money?
No, Your Honor.
Injunction? Are you seeking declaration?
We're seeking declaration, but we're asking for summary judgment to Petitioner Roberts.
Why is the case moot then? This was an ordinance that was good for one trip on one day. just like one of those tickets on a railroad. The ordinance is over, as best I can tell. So why isn't your case, why shouldn't we dismiss the case as moot?
Because, Your Honor, this case is particularly important to set the standard for governments that enact one-day policies that inhibit the free speech of petitioners like
May be
Roberts.
important, counsel, but I echo the Chief Justice's question. If it's moot, and that's the end of it. And this is a one-shot ordinance. The occasion has passed. Does the fact that the town council reserved the right in some undefined future time to impose it again, leaving aside the verities of that, does that render it not moot?
Your Honor, cities and local governments need to know that one-day policies that are content-based, that infringe upon the First Amendment.
That's a political argument.
Yes, Your Honor, but they need to know that these one-day policies are content-based and are unacceptable. Now, our first...
Let me ask you a different way. How likely is this to recur?
It's very likely if this court does not award summary judgment to Petitioner Roberts today.
Why do you say that? Has this ever happened before, as far as the record shows? Has this kind of ordinance been passed anywhere in, let's start with this town. Has this town ever passed such an ordinance before, as far as the record shows?
The record doesn't show the complete legislative history of the town of Somerville. However, the nature of this government action is particularly relevant. Our first contention is that this protest policy is content-based, as evidenced by its applicability only to the date of March 30th. We submit to the court that the clause within the policy is merely a pretext which states the obvious. It is non-binding and is of no effect.
So which clause is this?
This is the clause that states the council reserves the right to restore the policy for other similar events.
And what are you saying?
We are saying that it is content-based because it applies only to one date. And this law is supported by the city of
But
Renton.
you can't have it both ways. If it applies only to one day, and that's your view, then you lose because the case is moot. There's nothing to declare. If it applies in the future, then that undercuts your argument about it being content-based.
There's no case or controversy. Where is the case or controversy?
Your Honor, the case or controversy lies in the injustice that Petitioner Roberts suffered, and we need this court to declare that this policy was content-based and that it must be subjected to strict scrutiny. Here, the Court of Appeals has subjected this case to intermediate scrutiny.
Okay, let's pass over for the time being for the question of mootness. Explain to me your content-based argument. In what sense is it content-based?
This court has stated that a policy is content-based if it cannot be justified without referring to the content of the regulated expression. In Hill v. Colorado, this court stated...
Here they had noticed that this would be a matter of substantial public interest. They had reports from other towns that whenever they've held similar meetings, there were a lot of people showed up and there was a lot of disturbance. People got arrested, people got hurt. So the town wants to deal with this problem. Why is that content-based? They don't want people getting hurt. They don't want people being arrested.
Your Honor, that interest is valid. However, they may not do so in such a way that they're legislating based on the subject matter. When a government enacts a content-based law, they have to enact it in a generally applicable manner, and they can only invoke the secondary effects doctrine when secondary effects are the purpose.
Are they legislating based on the subject matter, or are they legislating on the fact that they had a one-time occasion which required regulation?
Your Honor, they had the option to have a law on the books. We contend today that by this policy applying to March 30th only, that it was an indirect way of regulating the subject matter because on that particular day, the only event going on was that the senator was hosting
What you're saying is it's facially no good because it cites a particular occasion. And doesn't it also cite the subject of health care?
Yes, Your Honor, and our contention is that this policy didn't have to apply to every town hall. However, the the town could have legislated in such a way that if this policy was ever needed again, that they could refer back to it.
Counsel, what do you do with this court's case in Hill versus Colorado?
Pardon me, Your Honor?
What do you do with the precedent of Hill versus Colorado?
We say that Hill supports us. It says that regulating the subject matter of messages is an objectionable form of content-based regulation. Your Honor, I recognize my time has expired. May I complete my statement? Hill says that regulating the subject matter of messages is an objectionable form of content-based regulation. That supports our contention that by applying this to one date, they've regulated the subject matter of expression indirectly, and therefore this is content-based and must receive strict scrutiny. And now my co-counsel will discuss the enforcement of the policy, and we thank the court for its time.
Okay, thank you.
May it please the court, good evening, Your Honors. My name is Joanna Robinson, and I'm co-counsel along with Ms. Hooper on behalf of Mr. Roberts. Now, as my co-counsel mentioned earlier, I will discuss why the policy was not narrowly tailored to serve the government's interest and how this resulted in viewpoint discrimination as applied to Mr. Roberts.
Are you bringing a facial challenge or an as-applied challenge?
We are bringing both, Your Honors. Facially, the policy as it stands, and just to clarify our contention with the face of the policy itself reserves the right for the council to reinstate it at future events. Our problem with, yes, Your Honor.
Let me interrupt you to say, which do you think stronger? Would you address it first?
I would address the as-applied challenge first, and that's what
Proceed.
my argument is focused on, Your Honors. So, as applied, this policy is invalid. First of all, the policy itself lacks specific guidelines to guide enforcement, and this, Your Honors, we believe is a major flaw of the policy itself. Now, Your Honors have held in Forsyth County, Georgia v. Nationalist Movement that.
I'm sorry, don't they have a map? They show exactly where people can get permits. I don't understand. How is this? What kind of guidelines do you need?
Well, Your Honors.
First come, first serve. They said there's no discretion in issuing the permit. First person shows up, gets the permit. Second person shows up, gets the next permit. They can't say, "Oh, we don't like your face," or "We don't think, we think you're going to be boisterous or unruly," or "We don't like the point of view you're going to represent." Person shows up and asks for a permit, they get a permit, right? What could be clearer than that? And why is there what's lacking there?
Well, Justice Kozinski, the permit scheme within the policy, it was based on this first come, first serve basis. However, the actual enforcement of the policy itself, in terms of when it was supposed to be applied, how the manner in which it was supposed to be applied, all these the essence of actually applying the policy, no directions were given, no instructions were given in the policy, were written into the policy.
That's the kind of stuff that's appropriate it's an ordinance, not a statute, but isn't that the kind of thing that goes into, if anything, implementing regulations, or simply the discretion lodged in public officers?
Well, Justice Stucky, the problem with leaving such broad terms in the policy and leaving that up to discretion is this, that the result is that average person, reasonable people will interpret those very seemingly simple terms in a variety of ways. And the gap in the policy that allowed such unfettered discretion for the administering officials of the policy, it allowed their unfettered discretion to be based on biases, which then served as a basis for triggering the policy and applying it.
Tell us the worst part of the policy. What's the worst part, the most discretionless, I said that probably backwards, the most discretion-giving part of the policy?
Okay. Well, Your Honors, on page 21 of the record, excuse me, Your Honors, I misspoke. On page 17 of the record, it states only a single instruction in one line. It says that this protest policy was enacted to regulate activities outside of the town hall meeting. Now, Your Honors, the activities taking place outside of the town hall meeting on March 30, 2009 were activities directly associated with political speech. Now, in order for an ordinance to regulate these activities in such a broad way, right, without defining what was allowed,
Well,
what
let me
was...
ask you the same
Yes, sir.
question I asked your colleague. Are we regulating speech here in the sense of something that's facially or as applied unneutral, or are we simply saying we have a situation here that we have to do something about? You seem to be saying that because the intent of the thing was to regulate this meeting, therefore, it's either facially invalid or invalid as applied. But I'm not sure I'm following your logic from A to B.
I'm not sure I understand your
sorry.
question.
Okay, how do you get to invalidity from the simple fact that they're dealing with a particular meeting or event, albeit admittedly political?
Okay, well, let me address your answer in, if you would just allow me, two ways to address your answer. First, because the policy allows for reinstatement, our contention is that the town would be able to reinstate the policy in an event that the topic consisted of.
Well, which way does that cut? I mean, if it were just for one thing and they didn't save the opportunity to reinstate it.
Yes, Your Honor.
Does that render it more or less suspect? If you had, one could think logically that if you had a policy concocted by its terms only to regulate one item, that would render it more suspect rather than less. Here they're at least opening the door to general application. So which way does that cut?
Well, Your Honor, I don't believe that they were opening the door to general application because it stated that the policy may be reinstated. It didn't say that it shall be reinstated, and there's a problem. It's very loose. And it allows for this discretion, then the unfettered discretion, to then be the basis for when the policy would be reinstated and how it would be enforced if the council chose then to reinstate it. And this discretion is evident from the record, the facts in the record showing that this unfettered discretion that was allowed to fill the gap of a policy that was supposed to contain standards resulted in...
Sure, what kind of standards you're talking about? Standards as to how they could protest, or standards as to how they could issue the permits? Or what are you talking
Well,
about?
standards in terms of how to enforce the policy. Now, an example of this comes from...
That's such an abstraction. You got to tell me something concrete.
Well, Your
What is it that give me an example of something that the policy should have said it didn't say.
Well, the policy should have said, or I think the biggest...
One example, just one example. It should have said what?
It should have said that intermingling, allowing protesters to intermingle, anti-healthcare protesters and pro-healthcare protesters were allowed to intermingle. Instead, it just says to regulate activities. And the discretion interpreting that...
That's not so hard. I mean, they have zones.
Yes.
People get a permit, and they're expected to stay in their zones.
Well,
and the whole point was to keep them apart so they wouldn't fight.
that's the problem, Your Honor.
Why is that a problem?
Because the policy itself does not state...
Fight?
No, Your Honor.
Want to fight, right?
We don't want them to fight at all. But what we don't want to do is restrict a certain group just because they're of the fear that they might incite another group based on their political message on that day. The court has never held...
You think they were required to allow them to go face-to-face, cheek to jowl with each other?
Excuse me, Your Honor.
Where is that in the First Amendment?
Excuse me, Your Honor. I'm sorry.
They are there to protest and express their views, and they say, your group on the right, the other group on the left, and we don't want you getting in each other's face. That's how fights start.
Well, Your Honor, based on the record...
You're really going to tell me that the First Amendment requires to allowing them to reach within punching distance?
Well, the First Amendment does allow the right to free speech. And if that speech
You have free
offends...
speech over there, not someplace where you can punch out or get punched out by somebody else who disagrees with you. You're really going to stand on the idea that they have to be allowed, we have to trust them to get close enough so they can start a brawl?
Well, Your Honor, I would really, I propose tonight that they should have been allowed to intermingle, because the way in which Mr. Roberts was conducting himself.
What case do you have that stands for that proposition?
Excuse me?
Which is the intermingling case? Which one of our cases do you rely on?
Well, Your Honor, the court's decision in Republican Party of Minnesota v. White, there the court stated that, excuse me, Your Honor, may I have a moment? The court stated that in order for regulation to be narrowly tailored, the government must demonstrate that the regulation does not unnecessarily circumscribe protected speech.
Well, counsel, I asked earlier about Hill versus Colorado. Hill versus Colorado says you can separate the people who are going to fight, I think, is the whole point of that case, the abortion clinic case.
Yes, Justice
So
Benton.
why does that defeat your point?
Well, Justice Benton, the record indicates that there was no threat. There was no threat of brawls. There was no threat of animosity on the part of Mr. Roberts and his group. They were conducting themselves in a completely lawful manner, and they did not pose a threat to safety, order, or security. This is a problem. When they were kept confined to a group, it was for no justification other than the disagreement of their
You
message.
have to wait for them to come to blows before they can separate them? Why can't they take the lesson from many other towns where they had reports that when people on opposite sides of this very divisive issue come to face with each other, this is something that tempers run high, and people tend to get physical. So the town says, look, you can talk all you want to, but we're just not going to let you get, we're not going to repeat the sad experience of these other towns by letting people on opposite sides get close enough to fight. Doesn't that seem both sensible and entirely legal?
Time.
May I answer your statement?
Okay, I just asked a question.
Thank you, Justice Kozinski. Your Honor, just as the town of Somerville looked to other policies, looked to other states to identify the potential threats of brawls and congestion and traffic issues, they could have looked to other states to find a valid way of instituting or drafting a properly constitutional policy so as would not allow such unfettered discretion by administering officials that resulted in the abridgment of Mr. Roberts' rights. And I thank you for your time.
No other questions right now. We'll hear from the respondent.
Mr. Chief Justice, Your Honors, may it please the Court. I am Jacob Nye, and I and my co-counsel, Lauren Fromme, represent the respondents, the town of Somerville, Missouri.
Your name?
Jacob Nye.
How do you spell that?
Last name is N-E-U.
Boy, huh?
Yes, Your Honor.
And co-counsel?
Fromme, F-R-O-M-M-E.
And you are the counsel for respondents?
Yes, Your Honor.
Why does your brief say counsel for petitioner?
Your Honor, I believe our brief does say counsel for the respondent.
Is this your brief? Maybe I've been given the wrong brief.
It says brief for respondent.
I understood that, and I was wondering why a brief for respondents was being filed by counsel for petitioner. So you're not counsel for petitioner?
No, Your Honor.
You're sure about that?
Yes, Your Honor.
Because
Apologize for
we might have,
mistaking.
and aside from a mootness problem, we might also have a lack of case or controversy problem.
Yes, Your Honor. I apologize for the oversight.
This is a case of poor proofreading on counsel's part?
Yes, Your Honor. I apologize for that. As I was saying, Your Honor, represent the respondents, the town of Somerville, Missouri. It's Mayor Sarah Johnson, Police Chief Mark Cato. Asked this court to affirm the Eighth Circuit's ruling granting summary judgment to the respondent. Respondents will show that their protest policy is content neutral and that it satisfies the ward.
Are you conceding that there's a case of controversy here?
Yes, Your Honor. Under Section 1983, any person whose rights are violated may sue for injunction, damages, and attorney's fees.
They said no injunction, and I believe they said no damages.
No, Your Honor.
So I'm just asking, what your position is. I mean, you can't waive mootness, but I would certainly like to know what respondents have to say on the mootness question.
Well, on the mootness question, if they are not asking for injunction or damages, we would believe that it is moot, and that therefore we're welcome to walk right out right now.
Thank you. You're the lawyer. What about declaratory relief? They seem to want declaratory relief.
If they wanted declaratory relief, Your Honor, that would prevent the town from reinstituting the same policy at a future event.
Can you get declaratory relief on a policy that's not now in effect?
I would think not.
To research that, wouldn't you?
Yes, Your Honor.
Okay. Why don't we assume there is a case of controversy here? Although I must tell you, it's very iffy.
Oh, yes, Your Honor, assuming there is a case here and that the question is whether or not this is a content-neutral or content-based regulation, respondents believe that this is a content-neutral regulation and satisfies Ward under intermediate scrutiny, and I will address the content neutrality of the regulation.
Do you represent the chief of police here?
Yes, Your Honor.
Okay, what's his role in all of this?
The chief of police...
This is a declaratory action. What does he have to do with that?
If it's a declaratory action, none, Your Honor. I assume that they were seeking to obtain damages from him.
Wrong about that. So are you seeking to have your client, Mr. Cadell, dismissed from the case on grounds that there's no claim pending against him? And therefore
Certainly.
the case?
Well, counsel, what though if they have an as-applied challenge?
As applied...
The strongest point was an as-applied challenge.
Yes,
Wouldn't
Your
that apply
Honor.
to the police chief?
Yes, as applied would apply to the police chief in that case. The police chief had indicated...
He would have had a role in it, but he can't reactivate the ordinance. He's just a cop on the beat.
Yes, Your Honor, and that's exactly the town's point, is that he is simply enforcing the policy as was enacted by the town council, and he specifically said in the record that he was escorting them back to clear way for pedestrians.
Counsel, if I could sharpen it for you, the Minotti case from the Ninth Circuit is very persuasive to me.
Oh, well,
I expect that...
It's a court we often affirm here.
Yes. As often as possible. The Minotti case, I think, means we should reverse, assuming we abide the logic of the Minotti case, because there the court says that there should be an as-applied challenge allowed on very similar facts, the World Trade Organizations, the protests there. If we believe that Minotti's right, why doesn't that mean part of this summary judgment ought to be reversed, the as-applied part?
On 2 points, Your Honor. First, Minotti was, in that case, the police officer who was enacting the policy, so to speak, had essentially was filling ground. And whereas in our case, he was simply filling in gaps as basically acting as a policy maker for the town of Seattle in that case. In this case, Your Honor, the police officer was simply enacting the policy. He specifically said that this is to make way for pedestrians as was asked.
How do we know?
Well,
how do we know that there wasn't a meeting between the mayor, the city attorney, and the police chief where the mayor said, I'll get the city council to pass this ordinance. You, Mr. City Attorney, call up and make sure that those good spots up front where the cameras are going to be taken up by friendly demonstrators. And you, Mr. Police Chief, you make sure that when the adverse demonstrators try to get out of the corral where we stuck them back there behind the, behind the City Hall, you just make sure that they stay there so they don't get to the cameras. Why isn't this a sort of a tinker to ever to chance conspiracy?
Well, Your Honor, first off, the police did apply it equally to both sides. They did remove a pro-healthcare protester who tried to accost some men.
Well, but that's sort of like the right to sleep on the bridges. It applies equally to the rich and the poor. Keeping the one kind of protesters, the ones that are favored by the city up front and in their corral, in their area, is no skin off their nose because they are there, they are near where the cameras are, they get lots of visibility. So the fact that it's equally applied to the one protesters as well as to those in the back, to keep them in the back, it's sort of like, it's not really equality, is it?
Well, Your Honor, as Justice Stucky was pointed out, that yes, the man was drunk. However, the police officers were simply enforcing their normal discretion as police officers, and Hill allows police officers some discretion.
But assume with me there was a meeting like the one I posited, where so cigar-filled room, or maybe smoke-free environment, more likely in this case. The mayor, the city attorney, and the police chief got together and say, we'll take care of those rowdy protesters who are out of town that are I mean, there's certainly indications the mayor here headed in for these people, right?
Yes, she did make some.
You don't concede,
we concede that point.
That. And you don't dispute the fact that the city attorney headed in for them because he didn't call adverse protesters. He called people who favored the policy to get them to take the spots out front, right?
Well, I would add to that point that he did call a reporter who ran a story the next morning on those facts, and also
After it was too late.
No, Your Honor, he called him that night.
No, but the story ran after it was too late.
Don't believe so, Your Honor.
Ran the next day, right?
Yes, Your Honor.
Okay, proceed.
Okay,
Go ahead.
you seem to say in your brief that he was out on a frolic of his own when he was doing this.
Yes, Your Honor.
Did he do it from his office?
Yes, Your Honor, he did.
Did he do it on his phone provided by the city?
Yes, Your Honor, but
Did he do it on city time?
no, Your Honor, is after the meeting.
No. Did he do it during the workday?
No, Your Honor, he did it that night.
Okay, he did it that night, but he used city facilities to do it.
Yes, Your Honor.
Okay. Why doesn't that render this staggeringly open to an as-applied challenge? You take, leave aside the facial language. You got a mayor that says, we got to get something here to keep these nutcases out of our fair city. You got a city attorney that says, okay, you non-nutcases, get over here and take up A and B, which they do. Leaving aside the cop and his references to the folks in C, why doesn't that render this, absolutely, open to an as-applied challenge? I mean, you're applying it, where are we?
Yes, Your Honor. The policy itself does not actually create any,
Yeah, the policy
Right.
does, but that's not my question. My
Yes, sir.
question is policy is applied.
Right. The attorney was acting on his own. There's no indication, regardless of perhaps wanting to conjure up a meeting, there's no indication, and petitioners do not allege such a meeting. And
Is he cloaked with the authority of the city?
Yes, Your Honor. However,
Isn't he using city facilities?
yes, Your Honor.
How is he on a frolic of his own?
Because, Your Honor, he's allowed, as any person who had attended the meeting would be allowed to call and get their groups to come to the meeting.
No. He's not calling on behalf of a group. He's calling groups.
Yes, Your Honor, and Councilwoman Marsdale would have been able to do the same thing. Councilwoman Marsdale, who was an anti-healthcare person, would have been able to do the same thing.
Had he known about it?
Had Councilwoman Marsdale, she held.
Oh, I'm sorry. I misunderstood who you said.
Oh, I'm sorry. The Councilwoman Marsdale, who was involved in actually passing.
Okay. I thought you were saying something else.
Thank you, Your Honor. I'll cede to my.
Well, you did say something I wanted to ask you about, and that is, you said they haven't alleged such a meeting. How do you know?
It's not in the record, Your Honor.
So you don't know whether they alleged it or not?
They haven't. It was not in their complaint. I mean, they would have brought. They would have.
You don't have a complaint, do you?
No, Your Honor. There is no complaint.
I don't have a complaint, so I assume you don't. So you don't know whether they alleged anything like that?
No, Your Honor.
What you can really say is, we don't know of any such allegation.
Well, on a summary judgment question, I would expect them to have brought evidence of such a meeting, at least provided such an affidavit to the court.
but you said they didn't allege it.
It's not, they're simply not in the record, Your Honor.
You don't know that it is in the record.
I know that it,
We don't have a full record in this case.
yes, Your Honor, we do not have a full record.
Thank you.
Your Honors, may it please the Court, my name is Lauren Fromme. As my co-counsel has just addressed, Respondent's policy was a content-neutral regulation which the Town Council enacted in response to serious concerns about safety, order, and the free flow of traffic at upcoming Somerville Town Hall debates.
You got to admit that they worked it pretty good to stick it to these petitioners. They pass a policy that maybe on its face is neutral. We can talk about that, but let's concede that for you. And then they immediately get people who start manipulating it. The city attorney calls up his friends and get them to grab the first two permits, once up front, and then the chief of police himself. I mean, you remember what statements that are on the record about what he said about these people. So it looks pretty fishy, doesn't it?
Well, Your Honor, while it may look fishy, that doesn't make a constitutional difference. In this
Don't we
case,
need a trial for that? I mean, isn't it fishy enough? Haven't they raised enough of an issue here so that what are you afraid of? This would be a jury of citizens. You should be very happy to go before them and get the city vindicated.
What quantum of fishiness is necessary to overcome a motion to summary judgment?
How much must it smell?
it must smell like Minotti, Your Honors. You rightly bring up the Minotti case. In Minotti, there was evidence of a widespread abuse of almost a policy that the city had adopted. And that's what has to happen for an as-applied challenge. There has to be a policy. Here we have one statement by Officer Cadeau when he was enacting the policy within his discretion, bringing the petitioners back into those very defined zones that are outlined on your map. We also have the attorney...
But in that case, it happened to be a zone where nobody could see their protest. He might as well have told them, get out of town and protest all you want out in the desert.
Well, Your Honor, you're speaking to the ample alternative means of communication prong of the Ward Intermediate Scrutiny Analysis. Yes. And...
I knew there was some wisdom there.
Well, counsel, I'm not so concerned about what he said. I think that's important. But what he did worries me. There's an open sidewalk, an open public sidewalk that's not covered in the policy, as far as I can tell at all. It's across the street. It's prime space. A few of them try to go over there where anybody can walk during the day for any purpose, the poor and the rich, can walk there during the day, and he won't let them be there.
Yes.
What about that? Doesn't that at least get these people a trial as applied?
Well, Your Honor, this case is very comparable to Hill, in fact. In Hill, there was a prohibition on protesting and counseling speech. You could not approach a patron of the healthcare clinics to protest or to counsel them. This case is very similar because you could not approach outside of your zone to protest. It's a protest policy. You are permitted only to protest.
What does the policy say that?
The title of the policy is protest policy.
No, I understand, but what does it say you can't go to other places like sidewalks or parks to protest? What does it say you can only do it there?
Well, Your Honor, it's a reasonable interpretation of this policy that's called a protest policy, and it assigns zones on the first-come, first-served basis and restricts activities.
So you're not taking the position that being on the sidewalk they were within striking distance of the other protesters? I'm trying to visualize this. By being on the sidewalk, were they close enough to start a brawl?
Well, Your Honor, in this sense, it doesn't matter. Hill...
It may not matter, but that's my question, so, for you it matters.
Yes, Your Honor. In Hill...
I'm sorry, the answer is yes?
Well, even though...
They were within striking distance? There are three possible answers. There's yes, there's no, or the record doesn't show it. So you can give me any of those three answers, but it has to be one of those three.
My answer is that, Your Honor, even if he was not in striking distance on the sidewalk, it's, that bears nothing.
You didn't hear my question. My question is not what would happen,
Mm-hmm.
why it doesn't matter. My question is quite specific. By being on the sidewalk, were they within striking distance? Yes?
No, Your Honor.
No? No.
No.
So now we're in the no zone.
Yes.
So they're not. So this is not a situation where they're being taken off the sidewalk to avoid physical violence, the risk of physical violence.
No, Your Honor. However, one of the goals of this regulation was to eradicate traffic congestion and to promote access.
You're making that up. What does that say?
Well,
Why wasn't the goal of this policy just as well to keep those crazy protesters from appearing anywhere near the cameras?
Your Honor, we
Where's
have
the traffic? I've got the policy right here. Where does it say anything about traffic?
we have two instances on the
I'm
record.
asking a question.
Yes.
Where does it say traffic?
The policy itself says security and order. When you look at,
Sorry, where you have it?
it's to promote security and order in the purpose of the policy as outlined in the
You
regulation
read that as
itself.
meaning pedestrian traffic?
Yes, Your Honor. When filled in by the evidence that the town considered, and we're looking at the evidence, for example, that Rebecca Marsdale brought up when she first considered the idea of enacting a protest policy, she said she'd been reading articles about traffic congestion, noise, and unruliness at other locales where they had been doing election protesting.
Counselor, she's only one of 8 votes, right?
Yes, Your
But
Honor.
why should we pay any attention to her at all? Isn't that your normal position on what she says?
Yes, Your Honor. However, she presented this evidence to Mayor Sarah Johnson. Mayor Sarah Johnson then put the idea of putting a protest policy on the agenda for that year. They later enacted the protest policy
How did
specifically.
Marsdale vote on the protest policy?
Rebecca Marsdale decided not to vote for this healthcare, this protest policy for the healthcare. Yes.
Surely her
against-
views don't count. All right, go ahead.
Well, she presented the evidence that supports this policy, however, and the evidence fills in what the reasonable, the purpose of enacting this policy was. And in fact,
Let me ask you this. This policy aside, is there anything in the record to suggest that standing on the sidewalk by a group of 75 people was violated any law, ordinance, any statute? Was it?
well, Your Honor, both times when the petitioners went out of their zone, they went out of their zone to protest. They went out of their zone the first time in order to stand in front of the town hall to protest, and the second time they went out of their zone.
Talk about something other than the thing I asked about. This is not good.
Oh.
Yes? No? I don't know.
The
Those are the
policy.
three permissible answers. Was there
Yes.
anything, is there anything in the record that says, aside from this policy, we can debate what the policy means, prohibits,
Mhm.
but is there anything in the record, or anything of which we can take judicial notice, that would make it illegal for a group of 75 people to stand on the sidewalk?
It depends, Your Honor, on whether that group is protesting or not. The policy creates protest zones.
I said, aside from the policy.
Oh, aside from the policy,
Now listen to the question.
there may be traffic regulations permitting or prohibiting large groups.
Nothing in the record on that really, though, counsel,
But there's
right?
nothing on the
They were, not
record.
in, they were not in the street where you can sort of assume they said, oh, you
Yes.
can't block traffic. There were pedestrians standing on the sidewalk, right?
Yes.
I mean, I don't know, maybe Somerville is different from other towns, but most places, sidewalks are for pedestrians,
Yes.
right? It's not usually legal for pedestrians to be on sidewalks, right?
Yes.
Is there something that says if you have a group of 75 or more, it's illegal?
Not usually, Your Honor. However, this is a special circumstance. Senator Smith is coming to the town of Somerville. It's a small town.
Troublemaker.
It's a heated issue. They're expected to have a large group of people coming. The eyes of the nation are upon them. There's national media coverage. This town square has a roundabout, which provides for the sole access points to the police station and to the courthouse.
They weren't over by it, though. They're on the other side of the square, right?
No, Your Honor. However, they were on the other side of the square.
You have the
Yes.
diagram?
Yeah.
Yes.
The sidewalk's on the other side, right? The south side and the police
Yes.
station courthouse on the north side?
Yes, the police station was next to Zone C. However, because it was a roundabout, may I finish?
Must finish. I don't know why you guys keep asking questions like that.
Because it was a roundabout, standing anywhere in the middle of the road in the roundabout would impede
On the road, they were on the
access.
sidewalk, counsel. Go ahead.
Facially, Your Honor, the reason for...
Facially in the road?
I still don't know where they were. Do you have the diagram?
Yes.
Why don't you explain to me exactly where they were? And I assume that the diagram, the top is north, right? There's no legend to tell us.
Yes.
Okay? So where were they?
They were standing in the sidewalk in front
I don't even
of the
see a
town.
sidewalk.
They were standing in the sidewalk in the space between the businesses and the roundabout, right in front of the town hall entrance
So they
and outside of their zone.
outside the roundabout.
Yes,
So
protesting.
separating them from the other protesters and the town hall entrance
Yes.
was this street. The
Yes.
roundabout is a place where cars can travel, right?
Yes.
So we're standing on the sidewalk across from all that.
Yes, Your Honor.
And what do you think is the problem with that?
Oh, well, Your Honor, the town here creates a bright line rule, prophylactic bright line rule, just like the one in Hill. In Hill, some protesting was harmless. Some counseling was harmless. However, it's too much discretion. It's not protective of
Are you
speech.
admitting it's over-inclusive?
No, Your Honor. In Hill,
What you seem to just say.
yes, but in Hill, this court found that sometimes you need to have a rule that prohibits some harmless speech as well as some harmful speech because of the discretion problem that the petitioners are pointing out. Because this
Well,
is a...
the petitioners are saying that the whole thing is standardless. Are you saying, how do you treat their argument?
I'm saying, Your Honor, that there is a standard, and the
The
standard is...
absolute.
The standard is absolute.
Okay,
It's very
so it's a
clear.
bright line rule, and the fact that it sweeps otherwise permitted political speech, which is at the core of the First Amendment, into the trash can doesn't matter because the interest of the town in having a bright line rule trumps that.
I'm saying it's analogous to Hill, Your Honor.
Well, and
Well, in Hill, they had a distance that was specified in the statute itself, or the ordinance.
Yes.
So you could tell. What is it about the sidewalk here that brings it, I can't tell the distance. There's nothing about the ordinance. I mean, what if they had congregated 3 blocks away on the sidewalk? Would that have been like Hill too?
Your Honor, this regulation is like Hill because it says that you must be in your protest zone. You cannot approach outside of your protest zone, just like the speakers
So
in...
it's like a prison? You know, I mean, if they want to protest outside of town, that's no good? Or 3 blocks away in the park, that would have been impermissible?
This is effectively, Your Honor, a narrowly tailored regulation, narrowly tailored towards crowd control. And it's narrowly tailored in 2 ways. It provides access to the town hall, blocking off the roadways, and it also evenly distributes the protesters.
Why isn't it the case that why haven't they made out the case that this is all eyewash? This is all a pretext. And really, all this was designed to do is to make sure they are in the back of the town hall where the cameras wouldn't see them. But why don't they get a trial on that issue? That's really the heart of this case.
Well, Your Honor, you're speaking to the content neutrality of this. O'Brien tells us that you can't import the idea of one legislator to scores of legislators to the rest of the
But that's in a
people.
legislative context. We're dealing with scores of legislators. That's not this context. That's a dictum.
Yes, respectfully, Justice Stucky, there were 6 other council members who enacted this policy, and we don't know their reason for enacting it. We assume reasonably that the reason for enacting it is limited to the text of the statute.
Okay, and you got a text that says this is a one-shot deal aimed at one gathering on the subject of X. Now, how is that facially neutral?
Well, Your Honor, respectfully, in Hill, this court has said that simply because a regulation restricts speech where a certain discourse
Was Hill
happens.
aimed at one deal? Did Hill have a termination thereafter? Did it drop dead after that?
Hill was aimed at healthcare clinics only, Your Honor.
Okay, it was a statute of general application, was it not?
Yes, Your Honor. However, applying a statute to a certain location in space is analogous to a certain location in time. Thank you.
Okay, thank you. Did you save some time for rebuttal? Yes, Your Honor. Cases are always lost on rebuttal, but if you wish to take that time.
We have shown that this one-day policy is content-based. Hill involved a content-neutral, pardon me, Your Honor?
Ms. Cooper again?
Yes, sir. Hill involved a content-neutral, generally applicable ordinance with the interest being protecting individuals who are trying to obtain medical treatment, not order and security. Order and security deal with the direct impact of speech on listeners, and this court has held in Forsyth County and RAV that legislating based on the direct impact of speech via order and security are not content-neutral bases for regulating. Here, the execution of the policy and the strict confinement by the police was not authorized by this policy. This policy was unconstitutionally vague and led to unconstitutional, unfettered discretion by the police to move petitioners off the sidewalks, even though the protest policy doesn't say that they can't be on the sidewalks. And this court has held that such unfettered discretion is unconstitutional. Now, the order and security in this policy, the way to define it lies in its legislative history. The legislative history reflects concerns about brawls, arrests, violence, and, quote, right-wing crazies causing trouble, end
Doesn't
quote.
this fit into the second-order effects of cases like Renton?
No, Your Honor, and that's our exact point today. When you legislate on the direct impact of speech, that is a primary. No, Your Honor.
They had a disfavored category of speech, and they said you can nonetheless legislate on this disfavored category of speech because of its second-order effects.
No, Your Honor. Order and security are primary effects of speech. This was acknowledged by the Court of Appeals. There's no primary effects doctrine. There's only a secondary effects doctrine. Now, traffic and congestion are secondary effects, but they're not in the legislative history of this policy, and they're not on the face of this policy as its purpose. The purpose of this policy is, Your Honor, may I complete my statement? The purpose of this policy is to maintain order and security, and this court has held in Forsyth County and RAV that these are not a content-neutral basis for regulating. And once again, we want to emphasize the unfettered discretion by the police, ask for summary judgment, and we thank you for your time.
Okay, thank you. Case just argued will stand submitted. We are adjourned.
All rise.
Very much.
Give a round of applause for our competitors. You guys can sit down, by the way. I know the competitors. I just have a couple things we want to say, especially for people at the banquet. First, I know the competitors are very thankful we picked the most gentle bench we could find. Although I'm pretty sure none of you will complain about your annoying 3L judges anymore. I just quickly for the moot court banquet afterwards, it has been raining. I'm not sure whether it's still raining. I know a lot of people had indicated they wanted to drive. If you want to, it's very easy to get there. I'm going to just briefly explain. You can ask me again afterwards, but I'll try to make it easy. If you just take 21st Avenue in front of the law school south, take a right on Pierce, then a right on 24th, you'll be in the middle of campus. When 24th ends, the parking lot is right over the hedges. Don't drive through them, but you can drive around them and park. If you're walking, we're going to meet out of the west end of the school 10 minutes after the round ends and walk over there. Either way is fine, just to guys give you the heads up. Thanks.
Please be seated. Well, after due deliberation, and we've considered the very fine job that counsel on both sides did with this case. It was a tough problem. These cases are made to be tough and to challenge counsel and to bring out the best in terms of advocacy, and I think we saw it here today. Nevertheless, a winner there must be. We've been asked to pick the winning team, and the winning team is the Respondents, Mr. Noy and Ms. Fromme. We may have individual comments for the advocates. Some comments best made in private. In the spirit of constructive criticism, nevertheless, you all, both sides, got very adverse questioning, and you stood up. You stood up very well indeed. So I think you're all going to be very, very fine advocates. We are adjourned.
Thank you very much. Y'all are very good.
Thank you.
That was a bit rough.
It was.
And then there's two benefits.
manner.